Hey, I'm Cliff. Welcome to the Culture Law Podcast. Welcome to Washington Law. This podcast is separate from my role as an attorney. However, it is my job to educate and teach and put into context for you. And today we're going to be looking at Darrell Brooks's trial and specifically one of the issues that is coming up as far as technology and how they're going about the trial. And it's just really, really, really interesting how this judge is going about it. It's kind of brand new. And so I think by watching this video, you're going to get a brand new insight into something that's maybe never come up in the history of law. And just to start, we're going to watch some of the video of the trial and then go through what she's decided and some of the possible issues that have come up. And so what does the judge want to do? She wants to stop the destructive activity. She wants to get control back of the courtroom, or at least hand it over to the bailiffs. And how she's done that is by removing the defendant from the courtroom. The Supreme Court has gone over 3 ways that makes it permissible to do this for defendants. And that's what we're about to watch in this case. So let's go ahead and start the video. Go ahead.
The record will also reflect your choice of term to describe your appearance today.
I've briefly
Thank you, Your Honor.
read Illinois versus Allen. It didn't say, it didn't give any reference at all to him being present by audio or visual.
And so Illinois v. Allen is the case where they're talking about the 3 types of ways that he can, as a obstructionist type of defendant, is going to be prevented from obstructing the trial going forward. And what the judge has done is she's saying that there's now a 4th way that she's created.
In that case, whatsoever.
Which she'll talk about here in a second.
Strictly talks about the reasons that he was removed and the options that the judge had in that. One of them being that he could be bound and gagged. One of them being that he can be held in contempt and removed from the courtroom while the trial would continue, but it did not say anything about being present visually or audio.
And so that's pretty close to what they said. I've got the actual quote here. It says, permissible ways for a trial judge to handle an obstreperous defendant. I don't know if that's the word. Maybe an easier word was just like a defendant who's obstructing the trial through interruptions. 1, they can bind and gag them, which is what this defendant had mentioned. 2, cite him for contempt. And number 3, take him out of the courtroom until he promises to conduct himself properly. Now this judge is now going to implement a 4th way, which is brand new. Never seen this before, maybe. Not even possible up until a couple years ago. She's going to remove him from the courtroom and allow him to watch this on television, which she's done numerous times already. And then allow him to object and pass notes to the court through the other courtroom, which is, I think, probably the best of all worlds.
Audio.
Well, I appreciate you reading the case, sir, and providing that information. I'm well aware of what the case says. And as that case says, the Supreme Court talked about there would be no one formula for maintaining the appropriate courtroom atmosphere, and no one formula will be best in all situations. But the Supreme Court said this: we think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Allen, going through the 3 things that you identify. And my findings here are that there's a 4th way. And that's through the wonders of technology that weren't available in 1970 when that decision was authored.
Okay, so there you go. That's the judge's statement there. I'm going to go through and put this on a board just to show you what a potential issue might be and what the defendants raised in this case. Okay, so what we have here, we have the judge down here, and we have the jury box. We have the defendant's box, we have the prosecutor's box. Down here, we've got the pews here. Okay, if you've ever been in a courtroom, this might look familiar to you. And then we have the defendant. He usually sits here, prosecutor here, and then you have the jurors, in here, making their juror selection. A situation where he's removed from the courtroom numerous times, and he's removed into this courtroom over here. And so he's watching the trial on a television right there, right? And he's then making the decisions. But what the issue, and I think the judge had, acknowledged this early in the trial, is that his view is only like here of one of the cameras. And the other cameras are on the judge, are on, going this way also. And so this is just a dead zone, and he cannot see, he can't see the jury. So what happened was, he's saying that one of the jurors had given him the middle finger, and that and now the juror who's on the jury, this one right here, let's just say, is made it on the jury, and she gave him the middle finger. So now what happens is he's like, well, I didn't see the jury because, oh my gosh, can I make a freaking box? Okay. I didn't see the jury because I'm over here in this courtroom, and that's a problem. So now what I will say is that the judge, her argument, and let's go back here. You saw all the jurors, right? You saw all the jurors, and you should have known that this could have been a potential issue. And so when you saw all the jurors, you should have mentioned this. You shouldn't have waited for that juror to get on the jury to mention that this juror had flipped you off. Now, whether or not she did flip him off, I don't know if we'll ever know. But, given the circumstances, I wouldn't be thinking this was a crazy thing that a juror would flip this guy off. But anyways, this is a situation where the judge, I would think, probably has a pretty good argument there. That being said, this is potentially something that the appellate court is going to have to decide on. And I could see potentially a appellate court going, no, you need to not proceed with him in another courtroom where he cannot see the jury. So what I would say for this judge to avoid this issue is just follow one of the other three ways, just going forward. Obviously, I'm not giving this judge advice. She can do whatever she wants, but that would make sense to me. So she needs to either bind and gag him, cite him for contempt, or take him out of the courtroom until he promises to conduct himself properly. He can conduct himself properly. As you can see here in this video, this is one of the rare instances where he is having very normal conversations with the judge. And then it gets to the point where he gets in his head and he just will not let the judge proceed without him interrupting. And he thinks that he needs to jump in there and object to every single question. I've never seen so many objections in my entire life in any trial. So, it's literally he's objecting to every one just to make a point. The issue is the judge wants to move forward. The judge doesn't want to hold the jury up. The judge wants to have this done. She thinks she can do this with the new technology, but she's maybe running into some interesting issues that she probably didn't think she was even going to run into. So thanks for watching. If you like content like this, go ahead and click the like button. I should have mentioned that a lot earlier. But so click the like button today, and we will come out with more of these videos. And yeah, I've got other opinions on what we should do with people like this, but this is just a legal analysis here as to a very, very interesting court drama that we have going there in Minnesota. So thanks for watching, and we'll talk to you soon. Later.